Good morning. Good morning and welcome to everybody. If you could find a seat. I think most of you have found the continental breakfast. Be sure to make this very informal this morning, and if you need to replenish your coffee or juice or muffins, feel free to do that. On behalf of the Education Subcommittee of the Caregiver Resource Network, it's my pleasure to welcome you and to thank you all for taking the time this morning and the interest to join your colleagues for this workshop on the legal and ethical boundaries of serving clients with dementia. My name is Val Ambrose, and I serve as the chair of our all-volunteer committee, which is under the umbrella of the Area Agency on Aging. Our committee was started by fall cold. Our committee was started by Twink Fry about 4 years ago, who recognized at that time that there were multiple resources in our community for persons with dementia and their caregivers, but people maybe didn't know how to access those resources. So over the last 3.5 years, she has pulled together a number of folks, a number of professionals with various expertise. Our committee now includes 2 geriatricians, our speakers this morning, our first 2 speakers, a licensed social worker and a geropsychologist. We have a coordinator from the Area Agency on Aging. We have a recent MSW graduate from the University of Michigan. We have a professor from the School of Gerontology at Grand Valley, a person from the Adult Wellbeing Services. We also have an associate director of the AAA, the Area Agency on Aging, a representative from Clark Retirement, and the head of the Alzheimer's Association. So it's a very diverse committee with great expertise in the area of dementia. I first became familiar with this issue about 20 years ago when I was executive director at Evergreen Commons. That's a senior center in Holland, Michigan. One of our early members came to me one day. She was the wife of a former superintendent of the public schools, and her husband had been diagnosed with early onset dementia about 2 years earlier. At that time, there was a bit of a stigma with Alzheimer's, and she didn't want anybody to know. She thought it might embarrass him if his former colleagues knew about that. But she came to me in a panic one day. He had called all their insurance agents, all of their health providers, all of their financial planners, and had canceled everything. All of their policies had been negated, and they had nothing. He had been approached by a scam artist who had taken away all of their retirement savings. Everything was negated. She was in her late 70s at that time. He was in his early 80s, and she didn't know what to do. She had checked with their attorney, and there was no legal recourse for her. She, at that age, was having to find a job again just to support them. She had no idea how she was going to care for him and provide for them financially. I'm sure all of you have heard similar cases, similar circumstances, and that's why you're here today. How can you help those folks who are your clients, those persons you're trying to serve, who may have a cognitive impairment, and how can you assist their loved ones and their families legally and ethically in addressing their needs? Because what she wanted, and I think what all of us will want if we ever have that same situation, is to stay in our homes as long as possible, to be with our loved ones. And so the information you received this morning is going to help you serve those clients by, first of all, understanding dementia and the various stages of dementia, how to communicate with persons with dementia, and then most importantly, or as importantly, what are the legal and ethical boundaries that you have to maintain in serving your clients and their loved ones who may contact you with concerns? Our committee's been meeting now for about 3.5 years and have done a lot of on-site visits with other service providers around the country. We've investigated what are the best types of services available, and we have determined that the best niche for us to fill is threefold. We want to provide information regarding community resources to persons who are caring for loved ones with dementia so that they can enable them to have a fuller quality of life. We also hope to foster innovative and collaborative initiatives between local agencies, medical professionals, and congregate living facilities. And lastly, and why you're here today, we're going to be providing education to care professionals and the community at large regarding dementia symptoms, diagnosis, and treatment options. We're going to give you a lot of information today. Much of it's contained in your packets. There are some PowerPoint presentations which are there, some community resources, as well as contact information for all our speakers. And joy of joy, there's an evaluation form. And you would really help us if you would fill this out and turn in it at the end, because this is only the first of several seminars that we hope to be able to offer to you and your colleagues in this area. Today is going to be a big overview, and in the future we hope to go into a little bit more depth on some of the specifics that you feel you would need. I'd like to give a thank you to all of our speakers today, a special thank you to our committee members. You'll be meeting them as the morning progresses, and a particular thank you also to our sponsors for this morning, the Area Agency on Aging, in particular the Caregiver Resource Network, Baker Holtz CPA and Advisors, the Grand Rapids Community Foundation, the law firm of Miller Johnson, the Nokomis Foundation, and Northern Trust. Thank you all for being here. Thank you also for seeking to better serve your clients who are afflicted with various stages of dementia, as well as their loved ones, so that you can be present to them and all those who are suffering from this disease. To take with you and share the information, again, you can take those packets. Feel free to copy any of that information and share it with your colleagues. We want to make sure that more people in the community hear what you're going to hear this morning. So now to kick things off, our first two speakers, two of our committee members, are going to be talking to you about dementia in general and communicating with persons with dementia. Suzanne Ogland-Hand, who is a geropsychologist with Pine Rest, and Kathy Brady, who is a clinical social worker, also with Pine Rest. Please join me in welcoming them.
Is this working? Is it working? Yeah. There. Okay. Let me come on up. Sorry about that. Are we okay with the sound? Okay. I'm getting the nod yes. So thank you for coming today. I think the title is interesting. Do you have clients with dementia? Really, we know we all have clients that are struggling with cognitive problems. What we're going to be focusing on during this next half hour is our overview. In your handout is a PowerPoint presentation for this talk, so I encourage you to pull that out. What we're going to give an overview is the issue of diminished capacity. So when someone's capacity gets to the point that they're not able to make decisions regarding their own medical decision making or their financial decision making, we look at that as diminished capacity. So we'll be reviewing some possible signs for you to be observing for, and then look at issues.
I think it might be because the microphones are very close together. I'm not positive. She's smarter than I am.
No, I don't know.
Was that it?
I don't know.
Okay, well, we'll try this. Is mine still working? Can you still hear me okay? Okay. Turn the other one off.
I can't do that. Goes from there.
Okay, we'll give this a try. Okay, so we'll be looking at possible signs of incapacity, looking at cognitive signs, emotional signs, behavioral signs, but we're really focusing most of our energy and time this morning on cognitive issues. And then what kind of mitigating or qualifying factors might also need to be considered. Where can you go in the community to get cognitive evaluations when you're referring patients? And then lastly, we'll be reviewing communication. Also in your packet is a handout called Capacity Worksheet for Lawyers. I would encourage you to get that out because we're going to be reviewing this in more detail. Also in your packets are from the Alzheimer's Association, the basics of Alzheimer's disease. They've got 10 warning signs, which we're not going to be reviewing in depth, but those are there. The focus of our talk is going to be more on things that you might specifically see in clients who are presenting to you in the circumstances that you find yourself. Where these are more of an overview, these 10 signs that are on page 5 and 6 of this handout. So to look at observing signs, go ahead. Do you want to just use my microphone?
Would you like that?
Put that
Okay.
down.
It wakes you up.
We're going to talk about observing signs, focusing on decisional abilities. Can this person make informed decisions? You don't want to look at someone who's just being agreeable with you, yes, yes, yes all the time, or being affable, or just trying to agree with everything you say. So you have to look a little deeper on that. Pay attention to changes over time. Now, sometimes you don't have clients that you have seen over time. You're just seeing them for one time only. But if you do have clients and you have seen them over the years, pay attention to any changes in their cognitive abilities and how much they pay attention and their decision-making capacity. Be aware of ageist stereotypes. So we all have those when, oh, they're just getting older kind of thing. But be aware of that, because don't fall into the trap that just because they're older, they might have certain characteristics. That isn't always the case. Be aware of red flags. A lot of it, red flags can be when they defer to family members. If they bring their wife in and they say, oh, my wife is always taking care of the finances, or my son always handles this for me. That might be a red flag. Is it always the case, or is it just the way it is right now? And then consider using that capacity worksheet. It says for lawyers, and some of you are not lawyers, but it's still a good worksheet for as you're interviewing someone or having the meeting with them, to make notes of what you're noticing.
And so I just wanted to briefly review this capacity worksheet that's in your packet. The first, observational signs, and I think it's important to say too, when we're looking for observational signs, there's not just one sign that you're looking for, and if you see that, that means the person has diminished capacity. What you're looking for is patterns of signs that would kind of marked, they're markers really, and taken all together, those are the things that then raise concerns about someone's capacity. So on that first page, the observational signs that you have are for cognitive functioning, and at the bottom of the page is emotional functioning. If you flip onto the second page, behavioral functioning, and we'll go into this more in depth. And then those, at the bottom of that page, some mitigating factors that you could be observing. And then if you look at the very last page, what's really nice about that in section D is it gives basically an overview of how to classify. When you've had interaction with a client, does it seem like they're intact? Does it seem like they've got some mild problems, which suggests that you would then proceed normally with the course of representing them? But if they have more than mild problems, you really only proceed at that point with great caution, where if somebody's got more severe problems, you definitely need to get other people involved in the process. So like I said, we'll be referring back to this throughout the course. If we think about possible signs of incapacity, we're going to review each of these in more depth. One of the most important things to remember is that dementia is actually not a normal part of the aging process. So by the slide here, you can see that belt height changes normally as we age, but cognitive abilities really don't. So thanks to Scott Halstead for that slide. So what is dementia exactly? What we know is that dementia is actually not a disease. It's a group of symptoms that are caused by a disease. It's a term that measures the severity of one's cognitive impairment. So for example, one of the things we strongly encourage people to get as much information as they can about their cognitive abilities. So when the doctor says to them, gosh, it looks like we're going to start some medicine for you that will help you with your memory, and they don't have any idea about what's the diagnosis that I've got here. So we really encourage people to get as much information as possible. So use the example of cancer. Say you went to your doctor and the doctor said, gosh, looks like you have cancer. You wouldn't end the visit there and say, oh, thank you very much, I'm going to leave now. You'd want to know, what type of cancer is it? What parts of my body are affected by this? What stage is it at? What's this mean for my prognosis for the future? What might I expect over time? And we encourage you to think about cognitive issues in that same way. So in terms of a criteria for a dementia diagnosis, when we look at the first piece is that the criteria includes multiple cognitive deficits. So it must include somebody having memory problems. For example, if somebody comes to my office, I could do a brief screen with them, give them 3 words to remember. I'm going to give you 3 words: shirt, brown, honesty. I have them repeat that back to me to make sure they heard the words and they got registered. And then I give them a small distractor task, and then a couple minutes later I'll say, what were those 3 words that I asked you to recall? If they can just tell me those words, shirt, brown, honesty, then we say they've actually learned the information that's there and they've stored that information. But if they can't do that, then we wonder, are they having some kind of a learning problem or a storage problem, that their brain isn't able to take that information in? But it could be that the information is in there, they just can't get it out. So then I might say, if they said, gosh, the words were shirt and honesty, but I can't remember the other one. If I say it was a color, and then they go, oh, brown. So that means that they're having difficulty forgetting stored information. So the information is in there, but they're just forgetting how to get it out of there. Or they might have a problem where they're having difficulty retrieving the stored information. And that would be an example of, even after I said, it's a color, and they go, purple? I say, no, it wasn't purple. Was it blue, black, or brown? Oh, brown. So part of the issue then is their memory problem that they're displaying is that they're having difficulty retrieving stored information. So to get a diagnosis of dementia, the first criteria is that they have to have some sort of a memory problem, and it can be any of those 3 types of memory problems. In addition to having a memory problem, they have to have at least 1 additional cognitive deficit. And that can be that they're having problems with language functioning, with what we call aphasia. So it can be that they're having problems getting their words out, expressive aphasia. It can be that they're having problems understanding what's being said to them. And it can be that they have a hard time coming up with the name of something, which is a very classic symptom for early stage Alzheimer's, is the naming function. It becomes difficult to come up with, but what's the name of this? You know, that writing thing. It's a pen. But somebody that's early in an Alzheimer's process would start to have difficulty with naming tasks. Another type of cognitive deficit is apraxia, so purposeful movement, where somebody might start having difficulty with movement activities. Another type of cognitive deficit is agnosia, so failure to recognize objects, not being exactly sure what they're supposed to do with particular things. And another type of cognitive deficit is executive functioning. And this is actually a function that's impacted by the front parts of our brain, and it involves our ability to plan, to organize, to sequence activities, to make sense out of novel situations. Executive functioning also involves abstract reasoning. So a task that's an executive functioning task would be a task of driving. Because while you're driving, you have to make sense of novel situations. You've got to pull in lots of different information. You've got to figure out how to sequence yourself in space. So when somebody has a diagnosis of dementia, they have to have a memory problem and then at least 1 additional cognitive deficit. They also have to have that these deficits that they're experiencing are causing them impairment in functioning in some way. Whether that's occupationally or socially, it's getting in the way of their everyday living. And it also has to be a decline from past functioning. So meaning that at some point in their life, their cognitive abilities were in this range, and now they're functioning at a decline from that. Part of the diagnosis of dementia includes the rule out of delirium. So it's very important that the person is not having an acute cognitive change that might be due from an infection process, like dehydration or something like that, that those issues medically have all been ruled out, and that the way the person's presenting is due to something different than a delirium process. In terms of the diagnosis per se, it actually can be related to general medical condition, to medication issues, to vitamin deficiencies, which is part of the reason it's so important that you look at that final criteria, which is that the diagnosis does not include prognosis. So just because somebody has a diagnosis of dementia, that still doesn't tell us what type of dementia do they have and what might we expect for the future, which is why this illness is talked about really as it's a family disease, because it's going to impact family members over time. Part of why it's important to encourage people to get workups for this problem, for cognitive problems that you see in your office, is if there are reversible reasons for the reason that this person is presenting in this way, we want to get those things treated. So it could be that they're having medication interactions, and that's why the person is struggling. It could be that their B12 level is low, or that they've got some metabolic issue that's going on that once treated will reverse what looks like a cognitive problem. I think it's also important to just briefly mention mild cognitive impairment, because it can start to impact someone's decision making. So that basically is a diagnosis that someone can get before they end up with a dementia diagnosis if they get a workup soon enough. So 15 years ago in this community, when I was running early stage dementia and caregiver support groups, we would be sometimes through the entire 7-week series before somebody had even gotten clarification or started the whole process of getting a workup for what clearly looked like ongoing, progressive dementia. Where at this point, 15 years later, we'll get people that have actually had workups and been able to identify it is that they're having mild memory problems, but they don't meet criteria for a dementia diagnosis yet, and that's because their functioning is still preserved. So it's not getting in the way of their everyday living and their decision-making tasks. So you sometimes will hear people talk about, I got a diagnosis of preclinical Alzheimer's disease, meaning the pattern of losses that I have evidence on testing looks like what we would expect to move into Alzheimer's disease over time. Or vascular cognitive impairment, where somebody may have some cerebral vascular risk factors or some small TIAs that have happened, and they're showing up with memory problems, but their functioning is still preserved. We know that it's a small percentage of folks that have MCI will convert to a dementia diagnosis over the course of a year. I believe it's about 20%. What we now know is that there are people that will have an MCI diagnosis. We've got data now that some of them will have that diagnosis for 10 years and still not convert into a dementia diagnosis. So we're learning more all the time, I guess. So part of the reason we put this information in there is just for you to have understanding about what a dementia diagnosis is, what mild cognitive impairment is, and how to help encourage your clients to not be afraid of this process, but to go ahead and get information, because as they have more information, they're able to do better decision making and planning for the future for themselves. In your capacity worksheet for lawyers, what's really nice about this on the first page is it gives examples of what you might see in your office setting. So if somebody's having short-term memory problems, you might see that they're repeating questions to you regularly, or perhaps during the course of an interview, you have reviewed information, and 15 minutes later or half an hour later, they're not recalling that you've had that discussion. Or they're able to talk really in depth about early times in their life and experiences of, their childhood and growing up, and but remembering what happened a few days ago isn't something that they're able to do. So those are really warning signs for you to be aware of, to think, gosh, it looks like this person is having some short-term memory problems. It could also be that somebody's having language or communication problems, where they're having a hard time coming up with the words that we talked about, or their language is very vague and not specific about things. And where Kathy was talking earlier about how important it is to pay attention to the decisional abilities and not just that somebody's friendly and can get along with you. You want the concrete data about what it is that they're talking about. You can also see that somebody can come across as pretty disorganized or has a trouble staying on topic. And another type of language problems are comprehension problems. So somebody might have where they're asking you repeated questions. One of the ways that you can try to tease this apart a little bit is to not ask your clients yes or no questions. Do you understand what I'm saying? Yes. Of course they're going to say yes. It's much more helpful to be able to say, could you just summarize for me what we've talked about? That will help you be able to make a determination how much they're really understanding about what you've discussed. And then the lack of mental flexibility and the calculation pieces, those are actually pieces of the executive function problem that we were talking about when we reviewed the dementia diagnosis. So if people are having a hard time being able to weigh alternatives as they're doing decision making, or if they're talking about having difficulty paying their bills, or difficulty figuring out, now how do I write a check again? Or if this is somebody who's always balanced their checkbook to the penny, and now suddenly they're not able to do that type of thing. You can also see people that start to develop visual spatial deficits, where they may have difficulty figuring out, how do they get to your office? They've been to your office numerous times, and now they're having difficulty with that, or that they're getting confused about, just disoriented about what day it is, what year it is, things like that. So all of those are basic signs to look at as raising questions. Gosh, I wonder if this is somebody who's having some difficulties, that it might be good for me to seek consultation, or encourage them to bring a family member in, or consider, have you had a workup done? You know, where are things in that for you? It is also possible that people are experiencing emotional difficulty, and Kathy's going to talk a little bit more about this, but where they're more anxious or more distressed, or if they're having difficulties with emotional lability, which basically means their moods are shifting back and forth, being kind of inconsistent with the topic. So that's other things to consider. Behavioral signs that you might see in your office have to do with delusions, which delusions are beliefs that are unlikely to be true, but it's important. So for example, if somebody is raising the issue, I think somebody is stealing from me, it's just going to be important to figure out, is that really true, or is that not really true? Hallucinations are actually sensory experiences that someone may have without having any stimuli for that. So it's hearing things that other people aren't hearing, seeing things that other people aren't seeing, or if somebody's coming in, the other behavioral sign that's possibly linked to incapacity would be if they're having grooming difficulties. Somebody that, you know, typically looks nice and is coming in, you know, with stains on their clothes, or things like that. Do you want to, we were just using one leg.
Oh,
right.
okay.
I'll take that. Okay.
We're going to talk about the mitigating factors and assessing signs of diminished capacity. In other words, don't jump to the conclusion that this person has dementia or is the beginnings of Alzheimer's, because there's a lot of factors that enter in that can mean that it's something else going on and you can catch it. One of the big ones is stress. Find out what's gone on in their life. Has anything changed recently? Did their dog die? Or someone in their family? Did their son lose their job? Something that would mean that they're not concentrating. Something else is in the way of their mind. So the other one is depression. Do they look depressed? Do they sound depressed? Depression can look like dementia because of the lack of concentration and attending to what you're saying. So we always have to rule out depression. And of course, anxiety and stress enters into making someone not be able to track what you're saying. There's reversible medical factors. A big one is new medications interaction of medications. Maybe they had a stroke or a TIA that wasn't diagnosed. All these medical issues can come into play. Normal fluctuations in mental ability in older adults are, it's normal to fluctuate. And we all are like that ourselves. It isn't just getting older. We do have times when we have down times and we aren't tracking the way we normally would, like at 6:30 in the morning as opposed to, well, maybe not 1 in the afternoon. Hearing and vision loss. Ask if certain times of the day are better for appointments. Suzanne and I have a lot of clients. Morning is not a good time for them. They wake up with a lot of aches and pains. They need to work that out, or they haven't slept well at night. So ask. Usually mid-morning or early afternoon is a better time when you see clients. Hearing and vision loss is huge. We have a slide on that, and I hope we have time to get to it. But you have to be attentive and ask them, are you hearing me okay? Do I need to sit in a certain spot so you can hear me better? And vision is a big problem too if you're presenting paperwork to them. Individual differences and variability, you have to take into consideration their education. Do they have a doctorate or did they just have 8th grade education? What your expectations are depend on that, and also on ethnicity and values.
Okay. So in terms of where you can go in town to get resources for yourself or to make recommendations for your clients to consider evaluation, we have a couple different memory and diagnostic centers in town. St. Mary's Hauenstein Center and their neurosciences. David Nienhuis is the neuropsychologist that is there who does capacity evaluations all the time. Dr. Kevin Foley is a geriatrician that works out of that office, and there are a number of neurologists that practice there. And then MMPC, Adult Neurology, has 2 neuropsychologists on staff, Dr. Mike Lawrence and Dr. Dave Bertram, both of whom do capacity evaluations. And they've got neurologists, Dr. Thwaites, on staff, as well as a few others, and social workers there. So we have some resources here in town, although it's not uncommon for somebody to go to Mayo or to go to Cleveland Clinic or to go to Ann Arbor to get a workup. We do have resources in town. In addition, we also have resources that have very strong psychology staff. So Mary Freebed department, Dr. Jock Donders and Dr. Hood Strong run actually an incredibly phenomenal program. They're known not only locally, but nationally and internationally. They've done some tremendous work, and they have a very solid product that they will give in terms of doing these capacity evaluations. And then there's a number of practitioners in private practice. Pine Rest has the psychological consultation service that's available, and the Alzheimer's Association also has a list put together of these are places that you can go in town to get capacity evaluations and to get geriatrician evaluations. Also, like I was mentioning, practitioners in private practice, Dr. Dan Rosen does a lot of this type of work, as well as Dr. Lori Reinecke.
So very quickly, we're going to finish up with communicating with someone that may have a diminished capacity. And I'll just run through it because you do have the slide there. So use simple questions and keep on topic. Don't switch a lot of topics. Go very slowly. Encourage unspoken communication and watch for unspoken communication. It's very important to, before they answer a question, if they look at their spouse or their son or daughter, whoever's with them in the room, if they look for, to make sure they're right, that happens a lot. So be sure to watch for that. Allow extra time for responses. Allow time for them to think about what you've said and form a response. The other thing is to make sure they heard you. Sometimes if they don't hear you, they'll just make up an answer. And so you have to be sure, did you hear what I said? Do you need for me to repeat that? Break information into smaller segments. Don't just stay on topic and finish that topic before you switch to another topic. Use a calm, gentle approach, very reassuring. It's okay. We're going to, let me just explain this again. Provide cues to assist recall, like Suzanne mentioned about recalling the word brown. You use a cue. Do not talk to the family members over the person who is your client. Make sure you include them in all discussions. I would also say, and it's not on the sheet, make sure you ask their permission. May I talk to your son about this? Or would you like to be alone in the room and not have other people present? Because you never know if they're being intimidated, unless you know the family, like I said, if you've known them for a long time. Always validate their feelings. If they seem nervous or stressed, just say, you seem a little nervous now, do you want to take a break? Would you like some water? Pay attention to those nonverbals. Repeat, paraphrase, and summarize as you go along. And make sure they heard what you said. And it's not just your hearing, it's, the understanding the words that you said. Always provide summary notes, and I would provide them if you could get them typed up before they leave. Or if your handwriting is good, maybe big print, again, because of vision problems. Schedule appointments for a time at peak performance, usually later morning. We talked about that. Sometimes it's better to schedule shorter appointments, just maybe half hour, 45 minutes. And it's always good if you could go to their residence, or if they're in a nursing home, go to the nursing home. If they're much less stressed being in their own environment. And I know the clients I've seen, and probably Suzanne too, they're really impressed if you come to their home. They find that, like, you just can't lose doing that. Addressing hearing loss, we've got to stop. I'm going to have you just read this on your own. And addressing vision loss. It's very simple. One thing about vision loss, anything you give them and typed up, make sure it's 14 to 16 font print double space. That's very important. And keep it on white paper with black print, no color paper or anything like that. So I'm going to just leave it at that because of our time. I don't want to get into the next panel.
Thank you.
Good morning. We are going to transition to a discussion here. I think any place is fine. My name is Tom Diminished. I'm with the Northern Trust Company.
Raffling the sauce.
We can check under chairs for that. We're pleased you can be with us this morning. I appear to be uniquely qualified to moderate this component, in part because I apparently spoke up too frequently at the planning meetings. So, lesson learned, take a note. Know that that's how that works if you're not careful. We are very pleased this morning to have two individuals that are going to participate in a discussion this morning on the topic that'll be tied more to the legal component of dementia. And in doing that, we're very privileged to have the Honorable David Murkowski with us. He is our Chief Probate Judge here in Kent County. And we thought that who better to hear from than a direct conversation with the decision maker around guardianship, conservatorship, as well as the trust and estate side of our practice. So we're very pleased to have Judge Murkowski with us this morning. We also have Julie Benson. Julie is an attorney and a professional guardian out of Northern Trust Corporation in Chicago. And so we've asked Julie to participate in part just from the professional side and that dialogue so that we have the ability to address the issue more broadly. As Val indicated, this really is an overview. Time permits us to give you that component. But we do have index cards on the various tables that you can feel free to either jot a question or a comment there that you would like either Judge Murkowski or Julie to address, or our two featured speakers, as well as then we're going to pull a panel up here at the end just for some dialogue around broader topics. So if you come up with a thought or a question, jot it on that index card. Lisa will be collecting those as we go through this process, and we'd love to address those. But we'd like to move pretty quickly into kind of a discussion on this topic. And I've had the privilege of a conversation with both Judge Murkowski and with Julie. And we thought we would start with you, Judge, just maybe, this is a really diverse group of individuals, as you can tell from just their life experience and their professional experience. Would you maybe set the tone for us with regard to just some broader definitions, this concept of guardianship, conservatorship, maybe even draw in a dialogue around a durable power of attorney or the designation of patient advocate, and just for the group set context to where we might take this conversation.
Thank you. Good morning, everyone. I'm pleased to be asked to participate on this important topic. I tried to do some homework over the last 2 weeks, except all the federal websites were down. But I did look up some statistics just to start and frame this, and I don't think a lot of statistics were talked about earlier. 64% of people age 65 or older in nursing homes have some diagnosis of dementia. 35 million people have dementia worldwide, and in 2012, between Medicare, Medicaid, and out-of-pocket expenses, we spend $200 billion in care. In Michigan, it's predicted that there's 250,000 folks or citizens with the diagnosis. And if we looked at dementia, I have one more stat that was stunning. If we looked at dementia, if it were a country, it would be the world's 18th largest economy, ranking between Turkey and Indonesia. And if it were a company, it would be the world's largest by annual revenue, exceeding Walmart at $400 billion and ExxonMobil at $311 billion. I take in probably 600 cases a year in Kent County alone out of my 4,000 filings a year that deal with either guardianship or conservatorship or protective orders. And we use protective orders typically on a single transaction. If there's one thing that needs to be done, as an example, create a special needs trust, that may be able to be done in a single act under a protective order. Guardianship, as we look at the definition, it's a high standard of proof. The standard is clear and convincing evidence. There has to be clear and convincing evidence by reason of either mental illness, chronic intoxication, mental deficiency, physical illness, chronic use of drugs, or another reason that that person is impaired to the extent that he lacks sufficient understanding or capacity to make or communicate informed decisions. The guardian takes care of the person. The conservator takes care of the estate. For a conservatorship, as we look at the definition, again, it's a clear and convincing evidence standard that the adult is in need of a conservator because he or she is unable to manage his business and property effectively, again, because of mental illness, chronic use of drugs, detention by a foreign power, mental deficiency. Actually, you hear that detention by a foreign power, and it's like, when does that come into play? But in the war, and there has been many cases where people could not control their assets during wartime. Mental deficiency, chronic intoxication, disappearance, physical illness, confinement, or another reason. And he has property that will be wasted or dissipated unless proper management is provided, or that money is needed for his or her support and care. So that is the basic framework that I have to use statutorily when I weigh by that high standard whether a person needs to be guarded or whether he needs to be, in the case of a conservatorship, a protected individual. And those are all terms of art that we use. Do you want me to go through the mechanics?
Yeah, I think,
I mean, anyone, including the person who the guardianship is sought, that person can ask for a guardian and conservatorship themselves under state law. You can come to the realization and say, you know, I'm either tired of making these decisions, I would like some help. So you yourself can file for guardianship and conservatorship. $150 filing fee, $12 for certified copies. It automatically triggers, though, a large, serious, cascading series of events that have to occur. Now, it seems like this seminar or symposium is bent towards saying avoid probate court. We're really nice people, and we do a really nice job, I hope, and think in servicing the community. But there are other ways to manage your person and your assets without going to court. It's required that you immediately, if filing is made, that you have appointed a guardian ad litem. That guardian ad litem, in essence, is the investigative arm of the court. I think I may have some guardian ad litems here. I certainly see many professional guardians here. And they do, and we're spoiled here in Kent County. I've seen reports in other counties that are fairly abrupt. I get these phenomenal detailed reports that talk about everything. What is going on in the family? What is going on with finances? What's the diagnosis? What's the person's behavior? Who around the person has been involved in whether it's good or bad? Sometimes cases come to me and it's just wonderful because everyone's come to this kumbaya moment that this person in our family needs help. Other times it's because someone has robbed a family member blind and an immediate legal intervention is needed to stop or staunch that flow of resources. So I see in both in good and bad light how that unfolds. That guardian ad litem does the report, 3 to 10 pages long. If it's an emergency, you can get a hearing in a day or two, whether that person needs medical attention, whether that person needs ECT, and we should maybe talk about that later because that's kind of an anomaly under Michigan law. A typical general power of attorney does not usually address ECT treatments unless it's specifically mentioned in your durable power of attorney, DPOA, durable power of attorney, as you all know. So think about that. We're compelled to look at less invasive modalities to juggle this person or to manage this person or finances. DPOAs, durable power for health care, trusts, all of those things can assist that person and family to avoid coming into court for a formal determination. After that, the report is done. Many times the person doesn't object or can object. Sometimes a family member will object. We either run a hearing that can run between 1 hour and 4 days if it's a fully contested guardianship and conservatorship. Then letters of authority are given, an order is entered, and that person has the authority to act either for the person or for those person's assets. If it's a conservatorship, we are going to, in public, as mandated by statute, since I am placing a third party in charge of someone else, there's accountability requirements. And what that means and what that triggers is that we have to know what those assets are, and that will become, in essence, public. Because I have to fashion a bond or try to make those assets safe either through bonds or through restricted accounts. Conservators can also have the authority to make trusts on behalf of their protected individual. Then we have annual accountings. We have annual reviews of guardianship, all mandated by statute. And again, I see this 600 times a year, and if you go to my court any Tuesday morning, Wednesday afternoon, Thursday afternoon, or Friday, you will see us conducting dozens of these hearings. So that's the general framework of, in Guardianship 101, how it unfolds in court.
Yeah. So the result of that process then often is appointment of either a professional guardian or a corporate guardian, or possibly a family member in that setting. But Julie, maybe you could give, again, this is a very diverse group, maybe you could give a little bit over the top of what a corporate guardian does, or how that role functions coming from the court's process once these decisions are made or in that process.
Sure. I think first I'll say that I'm going to be deferring to Judge Markowski because I don't practice in this jurisdiction. So as I said before, correct me if I'm wrong about anything as it applies here. But I think I'm going to continue with the theme of, in the end, you don't want to end up with me as your conservator. So go out and make sure you have all your documents in place. Within a few months of starting work in probate, I was a commercial litigator for 5 years before this. I quickly went out and did my documents because I didn't have them. I was just thinking, oh, I'll get to that someday. And I quickly realized I did not want to end up as a client of the team that I work with because we can be ruthless. So, but really, I think what you're asking me is the difference between the fiduciary trustee role and the, I think here it's called conservator, we call it guardian of the estate, but it's the same role. If we're acting as your fiduciary trustee, you've named us, you've had the benefit of working on the document with your counsel and determining what the rules are going to be should the durable power of attorney come into play. If you do not have these documents in place and you end up with a conservatorship, Judge Markowski is going to be deciding what happens, and I will follow the orders set forth by the court as to what will happen. And it can be a very expensive process because oftentimes I see children of persons both retaining their own attorney because they don't agree about how things should go. I see same applies to spouses, basically family members, especially when money's involved, quickly don't get along. And, a lot of times family doesn't get along anyway. So imagine when there's money on the table to split up, or they feel that it's not being spent in a way that it should be, such that there may not be any after that person is gone, they're the beneficiaries. So I think that in terms of once conservatorship comes into play, it just gets very expensive. I think that's the best thing you can tell people when you're trying to encourage them to get their documents in order. And I have a lot of friends that I've encouraged to do this since I started in probate about 5 years ago. And I still have people just calling me now, 5 years after the fact. And I think it'd be surprising to know how many people who are competent professionals don't have their act together when it comes to this stuff, because it's just one of those things that's on your to-do list. So not that I agree that in my county we're all very nice and the probate community is very tight-knit and do a great job. If you can get things together so you don't have somebody else making decisions for you, that's your best bet.
Judge, you alluded to the concept of undue influence. You talked a little bit about kind of those dynamics. Maybe you could just share your thoughts with this group around how things are presented to you, who presents, and some of the concerns that you have when you're in the midst of that process of reviewing and making the decisions that you ultimately have to make.
Well, let's remember that the goal here for everyone is to make estate planning decisions or decisions regarding your own care and supervision without crisis. That's our goal. I mean, when you are coming to court, typically there's an emergency unfolding, or you've gotten to a tipping point in your family for some reason. So the goal is always decision-making without crisis. We try to do a great job in Kent County, but the point is this, is that I become the decision maker. I'm going to decide who takes care of you, what they get paid, what happens to your asset. And there are many regulations in the statute to do it, but I become the decision maker then, or at least initially, and then your guardian or conservator. It is also privacy versus public accountability. So you have to understand that. You will lose some privacy because court files are open to the public. We have to have complete openness when we do these things in court, since we're issuing these orders. And again, the one thing that was said before we get to that is, it is a family disease and illness. It turns families upside down because, and I can say this because I had a mother who died from complications of dementia in 2001. Children become the parent, spouses become the caretakers until they ruin their own health sometimes, strain between siblings as to who is in charge, helicopter children who have never had a hand in taking care of their parents who live in sunny California, who helicopter down and say, I'm in charge now. All of those dynamics are pretty typical on a daily basis, so be alert to that. Now, what was your question?
No, I think you kind of hit on it. Yeah, I think, when you and I had a conversation, I thought it was quite interesting.
Well, the
around that
two
topic.
things that you will always see argued, if there is a contested litigation in guardian and conservatorship, is the two defenses are, of course, that someone exercised undue influence over the ward in signing those documents, or they did not have the capacity to sign certain documents. So that's going to be the drumbeat and the rhythm. I worked last night until about 1 a.m. because they are retooling the standard jury instructions, and they've asked me to participate that for the definitions of undue influence, and whether sometimes there are presumptions of undue influence, whether that person was a fiduciary at the time that document was signed on his or her benefit, that he gets the bulk of the money, whether they benefited from them, whether they exercise that. And so those are the things that get looked at when we make decisions. And you're going to see a number of things from, as far as litmus tests or what comes into court, from anything from, who paid the attorney's bill? Was it the child's attorney who received the bulk of the estate, who took mom and dad to his attorney or estate planner? Who was that child in the room when those documents were signed? Were they segregated? Has the estate planner or the attorney really done sufficient or due diligence in determining whether your client in front of you who's going to write you a check and who's paying the bill is another litmus test, of course, whether the son or the daughter is or the parent. So all of those things are kind of snippets of what we look at, or factors that we look at. What's usually a triggering point, and many times in many cases, is whether there's already a dementia diagnosis somewhere in a medical chart, and then a legal document gets signed. Now then that question becomes a tremendous gray area which generates tremendous litigation, and that is, a person, of course, can have that diagnosis of dementia and still, certainly on certain days, and the test is always at the time of the signing of the document, whether if that person has the diagnosis, and then they ultimately sign those documents. So it's always the argument. It's like he's already got a dementia diagnosis and he executed these planning. Many people argue that it's per se, those documents are void. Not really under Michigan law. But to write a will, the test, of course, and I think estate planners and lawyers should always know that when they're signing documents, and remind yourselves of that. What is the standard to make a will in Michigan? And that standard, although some people may disagree, that standard has gone up since we rewrote the trust code in 2010, which I did have a hand in at the state bar level. You have to know you're giving your property away after death. You have to know that the will is the vehicle that's going to dispose of that property. You have to know that what the natural objects of your bounty are, meaning who would you typically give your estate to? Do you know your family members? Do you know who your children are? Do you know who your spouse is, or whether you remember you're married? And you have to understand all of this in a cause and effect fashion, which is the last factor that was added under the new trust code, that you're understanding the effects of all of this and what you're doing. So that's the standard under the statute for both the creation now of a will and a trust. Michigan raised the standard for wills in 2010, or that was our goal, and that was really the goal of the Michigan probate judges, because the creation of trusts in Michigan has been what we always considered, or the baseline rule is that it's a contract standard. Wills, deeds, trusts, deeds, property transfers are a contract standard. It was lower typically. So the problem in a case would be that I could have a will with a pour-over trust, and my test for him or for the man or woman making the will would be lower. So the will stands, but the trust, which was technically and legally a higher standard, wouldn't make the test under Michigan law. So the will would stand and the trust would fail.
I thought an interesting story that you had kind of shared with me was of an individual of means who worked with their professionals to, on a regular basis. Yeah, I mean, I think it's of interest.
That's an amazing case that part of it came in front of me. I mean, how do you avoid all of this and stay out of court? I guess that's everyone's goal. Again, although we're very nice people and on the 9th floor here. There was a very, very wealthy individual in this county who owned several companies. And of course, it seems like half or a third of my cases are always generated by second or third or fourth marriages because, you know, the wife is there and she's lovely and the kids hate the wife. And so that's, you know, that's just a source. But what this individual did to avoid the fight with his family, and he had several children, a wife, and I think he had a mistress too, which is, you know, is that he subjected himself or submitted to an annual, basically mental status exam that was documented by his primary care physician or his internist, that was then placed in the file, and he would go happily every year and have that done. So when the kid says and show up and say, you know, he was out of his mind when he signed all this stuff, and he never would have done this, you know, and then every test comes out every year about how he tested, whether it was a BIMS test or a neuropsych test or an MMSE test, and I assume most of you know what those are. BIMS is a brief inventory of mental status. Standard MSSE tests out of 30 from making pentagons and putting hands on a clock and remembering 3 words like we talked about. But one way to do that from a practitioner's point is maybe to direct that client who has those means to have as some sort of regular cognitive testing. Very, very helpful and avoided a lot of problems in the case.
Yeah, I think, you know, with the group of professionals that we have in this room, Julie, you and I had talked a little bit about, and maybe just from a over-the-top, how you handle in your own administrative practice, this concept of kind of knowing your client. We've talked about that earlier today, but just each of us in whatever role we play, maybe just talk to that point.
Know your client is, I think, a really important concept that's, I think, become more popular recently. We're undergoing a huge compliance project at Northern Trust where we're knowing them in all sorts of ways in terms of, you know, social security numbers and collecting documentation, you know, dotting I's and crossing T's, and that's one aspect of knowing your client that I think people focus on a lot. But I think that the point that we tend to overlook sometimes, and you know, we're all very busy and have lots of obligations, is really getting to know the client in the sense of, you know, what are their interests, who are the important folks in their life. When something does happen, I think somebody mentioned, you know, a death, even the death of a dog or an important companion. You know, I have a client that I was the first person she called when she was telling me that her husband and her were getting a divorce, and she said, don't tell the kids if you talk to them because we haven't sat them down yet. And then, I was at the meeting where they told the kids, and then I'm brought in to discuss, all the other issues. And so, that level of intimacy with clients can be very helpful when you're dealing with some of these issues that you come to where somebody's not acting the way that you would expect them to. And if you aren't familiar with the people of importance to them, then you won't, know what to do, or you won't be as likely to know what to do when you get a phone call from somebody saying that something's wrong with that person, they're in the hospital. If you've taken the time to chat with the person a little bit more informally, you might know who it is that's calling you and remember, oh, right, that's their brother or whatnot. And I think it will be very helpful in kind of siphoning out who some of these folks are that might be taking advantage and who are advocates for these folks. And I think that there's a lot of red flags with people who, may be calling, asking questions, and you really need to stay on top of making sure you have written authority from your clients to speak to anybody. People can really catch you off guard, especially, with all of our numbers being published and things, calling, asking, saying that something's wrong, and you just really need to stick to those rules and not talking to people who you don't have authority, even casually. So I think that those are important things to know about knowing your client.
I think that what you have to remember as an attorney or an estate planner or the person getting the documents is that the documents are not static. They are not static, and they should be reviewed regularly for any number of reasons. Changes in the law, changes in marital status, death of a family member. So many people simply forget that they wrote that will in 1979 and they had a lovely 40-year marriage with their wife. And, Jane Wilson is named in the will, and she dies and he remarries, and Jane Wilson is no longer the wife, but that's the name in the will, and that triggers, of course, formal court involvement and maybe involve elections. So really on a yearly basis, even if you don't look for triggering mechanisms like death, remarriage, change in the tax law. I mean, not too long ago, we didn't have a federal estate tax. I saw one trust, and I'd be interested to know whether you have seen, I have seen one trust in the 8 years that had anticipated the termination of the federal estate tax, which is amazing. But, and that all means what? Go to someone who knows what they're doing. I had a case in front of me the other day where they get married, they already have children from previous relationships. She left everything to her daughters with some residue to the new husband, except the husband exercised his election under Michigan law, which is a very interesting and complicated procedure. You get your allowances, which gets technical. There's a formula that you get half, and what you took out of a non-probate asset gets calculated in. But out of this cute little $120,000 estate, the husband, who wasn't supposed to get anything, took $94,000 because that's the mandate under the formula under a spousal election. So the point of that story is not to have you figure out how to calculate the damn spousal election, because it took me about an hour to do it to make sure I had it right. But that you need to select someone who really knows Michigan estate and trust law.
Judge, on this topic of knowing your client, again, we've touched on multiple points of this, but you shared with me a dialogue around maybe what is often not known, that this becomes a true public situation, and someone might be named for a particular role, and then when you do a background check or you have to go through that process,
Well, we do, in Kent County, we do some best practices here, what we call here. Anyone who wishes to serve as a guardian and a conservator, I compel them because I need to know what they're about. They need to have a criminal records check, and we need to know whether they're on what we call central registry. That means whether there's been an abuse or neglect finding, and there's been a finding by DHS. It's a non-public record. usually regulating who can serve in child care or care facilities. But that's one of our tests that we use to protect someone that we believe is obviously vulnerable. So that means whether if your son wants to do that and he's a successful or she's a successful doctor, attorney, or whatever, that information will be exposed. Whether there's a mental health history, that information will be exposed, whether it's the ward or the respondent who's being asked to be given a guardian or conservator. And it's not because we're nosy, it's because we need to know the information in our best attempt to make this person be in the best hands possible. You know, after you do all of these wills and trusts and hear all these cases, it seems like in the last 8 years that I've been doing this, I keep thinking more and more about death, actually. I feel like Woody Allen. It's like I'm starting to focus on death. And, but in some ways, that's a good thing because really, and my wife keeps telling me, well, you know, we're living to 90 now. She's like, well, you're not retiring until you're 74, right? So, yes, those are the things you got to look for.
And I can just chime in that I witnessed a couple awkward moments in court. Maybe you've had this happen when you ask if, you know, they've ever had a felony, and the person looks at their attorney, and then they ask to go outside and talk for a little bit. And, you know, that's a good question to ask a potential guardian before you're before the judge, to avoid wasting some time and money.
Julie, I wonder if you could just share a little bit with the group or the audience about trends, things that you're seeing just from that professional side, the over-the-top guardianship. Things, again, we've talked about some of the broader topics, but things that you think this group in particular should know or that might make sense that we haven't necessarily addressed yet.
Sure. A lot of my files are actually minors and people with disabilities who have funds from catastrophic injury cases and things like that. But we have, I would say, noticed an uptick in the past few years of, and there's, I think, a lot of talk about this, with baby boomers aging up and knowing more about dementia and the signs and things of having elderly clients who are being adjudicated, and when there are a lot of funds at issue is when I come into play. And I have to say that every account like this that I've had come in recent years, it's always a problem. There is never a time where everybody gets along and it's great, whether it's siblings that are arguing, which is extraordinarily common. They all have their own attorneys. They're disputing the most ridiculous things, ticky-tack things, and they're basically spending all their parents' money arguing about all sorts of things. Then I've also noticed we've had a couple cases where elderly folks have boyfriends or girlfriends that they meet at nursing homes or wherever, and these people and their families have become involved, and it gets very complicated because the potential person who's being adjudicated wants to care for this person, but they're just their boyfriend or their girlfriend, they're not married, so it's just really complicated. And also, well, we said about children, but spouses, and I really think that spouses of the person who's being adjudicated or potentially being adjudicated, they just are under a ton of stress because oftentimes they're of the same age. I mean, you sometimes have the younger spouse factor too, but if they're of the same age, they so become overwhelmed. It's very stressful. Their children are fighting. So we definitely have noticed an increase. I mean, it's good for my business in terms of having more clients, and but it's really sad to see what happens to these families and the breakdown in communication. And it's never good for the ward because it's extremely stressful for them. The earlier speaker was talking about going to people's homes. I often do that because I find when they come down to court, they're just so anxious. Even elderly folks get real worried about like their ride and how they're going to get there and who's going to pick them up and what if it's bad weather. And so the more you can go out and see them at their home, I think that was really good advice.
As I think about the children in the family, and of course, we won't have a mechanism under formal guardian or conservatorship. Say you have a son or a daughter who's a drug addict or suffers with drug addiction. really the vehicle that you have to deal with wanting to leave part of that person's legacy to that child probably is best regulated by, certainly it won't be regulated because if I end up having the case, that money is truly the focus of the person who's under guardianship or conservatorship. But if maybe there's a person in the family who is receiving assistance on a regular basis, like an addicted child, it's probably a trust is the vehicle that can manage and maneuver and be nimble enough to manage that, where if there's periods of addiction, the trustee has the discretion to suspend either payments or part, or under Michigan now, as of last year, and I worked on that legislation, we allow what's called decanting in Michigan, which is taking a trust and putting those assets or morphing that trust into another trust under the discretion of the trustee to be able to be nimble enough to take care of an unforeseen or unexpected circumstance, such as the development of say something like a drug addiction, or maybe it ends up being an illness or something. Then you have that other big problem of coordinating that money, and maybe you use what we call a special needs trust, which preserves the assets of the handicapped individual, yet preserves their Medicaid eligibility for health care, which is another topic. But that is, I think there are many more options. There are many more choices that you have outside of court through all of those devices, say a durable power of attorney. I think we should talk a little bit about a durable power of attorney. It's what's considered a alternative to formal guardianship and conservatorship. The durable power of attorney law was retooled about a year ago in Michigan, which requires the attorney, in fact, the person making the decisions, to sign a form acknowledging his or her responsibility. In many times, I think it's a license to steal, even though it's a great vehicle to use, that it can assist and that person can manage money, can close and open accounts and things like that. But it's also can be a license to steal. And when someone writes in a durable power of attorney for finance that the agent in fact has unfettered ability to gift, well, hell, they always gift to themselves. And they said, well, the document says I can gift to myself. Well, under Michigan law, you still need, if there is still a fiduciary duty there, even there is a gifting requirement, and I have cases like that, and that gifting still has to be under the knowledge of the principal, the person whose money is being managed, and have their understanding and knowledge of that. But many people will say, I see a gifting requirement, so it's like, you know, the mom used to gift that, so I'm going to write a check to myself. So you have to be very careful, and I think there's always a dichotomy or a juxtaposition. You want to build, as a drafter or an attorney, you want to build as much flexibility in the document as you can, and the downside of that is you have a lot of flexibility. It's both a blessing and a curse. You have that flexibility. So you have these great broad powers, except you have these great broad powers. So it's very important how that person chooses who that agent under the durable power of attorney will be. And I think that they should always be, although they can, under the statute, you can make them and compel them to account and file annual accountings. So few people do, and that is really, it's always problematic. We always have to go backwards. We always end up demanding sometimes an agent under a durable power of attorney to account. And we have to recreate the wheel then. They're mandated to keep receipts and things like that. So just be alert to that, the provisions that are put in those documents, because they will both help you and sometimes used against you. So.
Part of the opportunity of having the judge with us and make these comments, there's a kind of a multitude of topics that we're trying to kind of cross over, and one of the ones that I think the group may be interested in understanding, certainly with the modification of the the estate laws, and the need today is not quite there to segregate assets between spouses in a structured way because of portability of the spousal allowance. Is that going to factor in any way when you get into either a conservatorship or you're making an allocation of assets? What does that process entail for you? And I know you have to set bonds.
I got to divide the asset, which is, I have this couple that's been married for 45 or 55 years. Now I have to determine who owns the asset, whether it's joint. Then I have to affix that bond amount. So then I'm having the spouse or the son post a bond. I've had bonds posted for $5 million. I've had bonds posted for $10,000. That premium's going to run between $300 and $5,000. But that is my backstop as a judge. That is my backstop because I am looking, if someone steals from the ward, I am looking, or the protected individual, I'm looking for a deep pocket here. I am looking for the deep pocket, and the deep pocket is going to be the bonding agency. And everyone gets mad at me when I set a bond. They hate it, but it's mandated under the statute. They basically talk about a $10,000 or $20,000 threshold now. But we set bonds. I sleep easier at night when I set bonds on people's cases where there is a conservatorship. It just has to be done. It's really mandated by the statute. But it's money out the door for a premium. But I need a deep pocket to recoup any losses from theft.
Julie, do you find your team in administering guardianships or in this professional capacity at odds with other family members around either the segregation or allocation of assets, or does the court do that heavy lifting for you, and then once you get your letters of authority, it's a defined estate or structure?
Well, first, I just want to point out, if you use Northern Trust as your corporate guardian, we don't have to post a bond, so that's an advantage.
But you have a deep pocket.
Right, we do. But we won't steal. But in terms of that, I think that there's an interesting dynamic between us as the corporate conservator and the courts, because I think that they rely on us to kind of filter the information from the family, and they're relying on us to bring forth the best solution solutions that the court can choose from. And so that is a difficult dynamic to navigate with the family, because a lot of times they just want you to do what they want and just to be a yes man and let the court say yay or nay to whatever the proposal is. And I think that in terms of preserving our reputation and acting in the best interest of the ward, we're often kind of the middleman in telling the families that whatever they're requesting is either not feasible, unethical, inappropriate, and because we don't want to bring that forth to the court because it'll undermine our reputation as a guardian and or conservator. And so I think that the families, they're often not thinking long-term. They're thinking short-term benefits to themselves. They're not thinking about the ward necessarily. So yeah, it's an extremely difficult kind of tightrope to walk in terms of, the families have filed petitions to remove us, and we've never been removed because usually we're trying to do the right thing. And I think that my relationship with families, they go up and down. Sometimes they like me and sometimes they don't, and that's my job. If they like me all the time, I'm probably doing something wrong.
Judge, we've kiddingly said that you don't want to deal with the probate court, you don't want to have a formal guardian, but it probably warrants some dialogue with this group around some of the broader things that you and your role do. I mean, as you and I talked, you're out in the multiple care facilities, you're meeting with people on a regular basis, reviewing. This is a very compassionate process. This is something that mandates not only, a commitment of time, but expertise. I just wonder from a view from the bench, from your standpoint, we've talked a lot about how do we not get into that probate court, but once we're there, once we're in, any thoughts, any just over-the-top advice for this group again, I was moved by some of the stories that you told of the people that you interact with, and it is so difficult, so challenging to watch individuals lose the ability to have that cognitive control. But I don't want to give the impression that you're not compassionate, that you're not an individual.
I'm only not compassionate to people who steal, and anyone who knows me, who's been in front of me as a guardian or an attorney, every person who has come in front of me that it's established that they've stolen an asset, everybody goes to jail in my court.
It doesn't go well for them.
I don't like them. I should say I don't like their behavior, but they go. And they also, many times, depending on, I don't want to say my mood, but depending on the circumstances, I'll make a referral to the prosecutor's office. You know, on the flip side, and we've talked about all this warning and stuff, you know, the great majority of cases, all we see really are unrecognized and unsung heroes. We see selfless wives and husbands who care for their spouses without a need for recognition, kids who really stop their lives sometimes, sometimes quit their jobs, sometimes move from California to Michigan or Florida to Michigan to provide care for their parents. Family members who pay money out of pocket if we don't have someone with a lot of means, who just write a check to care for that aging parent. So I don't want to lose sight of really the number of people who we see who just do yeoman's work in taking care of their family, who do nothing except get asked by us because of state statute to fill out any number of forms, any number of times on a yearly basis. We are blessed with, although it's been challenged by funding with DHS, we have a phenomenal, I think, professional guardianship program here. We have 30 guardians who do tremendous work. Much of the work is thankless. Many of them are here today. They make my life really much easier. We've had a crisis with running out of professional guardians in the caseload and reimbursements from the state, and where that money comes from. Some of it can come from senior millage, some comes from DHS, some of it comes from the VA. But it's not the typical. I mean, probate's an odd fish. You know, it's constitutionally mandated. But we deal with really the kind of nuts and bolts privacy issues. You know, you go to circuit court, it's like you got a contract, it's a company, you sue, you win, you lose, you get your check, you go home. If you're a felon, well, you're a felon, you face the dance, you know, you get convicted, you go to jail. But in probate, it's what are we going to do with your money? How are we going to manage you and your family? What are we going to do with your life? Where you should live? What kind of treatment modality should you get? Do you need electroconvulsive therapy as a last resort to fight this either depression or agitation? Do you get to go out of state? Do you get to change your domicile? What type of medications should you be taking? Should you be in a mental health treatment facility? Do you sell the family homestead for health care, sources of health care revenue to pay for that? Those are all on a regular basis, day to day, that any fiduciary, a guardian or a conservator, family professional, is going to face. It's not simple work. It's emotionally draining. I mean, you have, particularly with a family member, in some ways, the person who is afflicted with dementia, you know, sometimes they really have died before they're dead. I can say that because my mother had dementia. And so, you know, I get pressure. I'm from Milwaukee. I'm from Wisconsin. I have 2 siblings there. And I'm driving 300 miles, either myself or my wife, and it's a 290-mile drive. And in 1 year, we made it there 9 times, and the response was, "You never come to see Mom and Dad."
It's like, well,
I do, but it's like you never come to see mom and dad. And those are the things that you have to deal with. It's all a difference of, or a view of perspective, is what's going on. The last time I saw my mother was 2 months before her death, and I made that trip to Milwaukee, and I went to see her. She's in a phenomenal facility. And she was in a dementia unit, then she stroked, then she got moved to a different facility that dealt just simply with folks who needed care, not dementia related. So, you cue your mother, and I come in and I say, "Hi, Mom." And I say, "Hi, Mom, do you know who I am?" And she looked at me for a while, and she said, "Pete Scopter?" Well, that was my mother's optician. I thought, well, what the hell, that's close. And there is some humor to all of this. I mean, and she was in a little amphitheater in this lovely facility sitting with 20 other residents. The Music Man was on. I've driven 300 miles, so, it's like, I said, "Mom, would you like to continue to watch the movie, or do you want to go to your room and talk to me individually?" And she looked at me and she said, "Movie." So, what do you do with that? You sit and watch the movie with her. She doesn't know who you are. But those are the things you have to prepare yourself for and get figured out and deal with emotionally as these things unfold. I think maybe the one, I don't want to call it a benefit, but that person in some ways dies before the funeral. In some ways it's less painful because you've been preparing for it for 2 years. And quite honestly, our family did. We experienced some relief really after the passing of my mother, and I don't know if that sounds terrible to you or not, but we were, a big Catholic close-knit family who would, certainly fight amongst ourselves, but, defend the border against, non-family members. But it's that dynamic, and you gotta be alert to that. So.
Yeah, thank you for sharing that. Well, it is so telling, and we are very privileged to have an individual like yourself on the bench who has that component and that dynamic. And as someone who has both practiced and been over on the financial services side, we as professionals in this community are very privileged. And so thank you for taking time. I wasn't going to ask you to share that.
You are
story.
too kind, and don't forget, I am up for re-election.
Yeah. I wasn't going to ask you to share that story, but I am so thankful that you did, because you and I had that opportunity to have that conversation, and it is so meaningful for individuals to be able to hear that perspective. So I think what we'd like to do now is I would like to introduce Mike Faber, and then we will take a quick break. Lisa will collect up any questions that you have, and then Judge Murkowski and Julie and myself and our caregiver experts will come back up. But Mike is an individual that is, he's with the Older Learners Center of Grand Rapids Community College, and then he is also the co-chair of the Caregiver Resources Network. And he's very uniquely positioned to be able to hold a conversation for a few minutes with you around community resources and what's available. And so we're going to let Mike take this and have that conversation at this time.
Good, thank you very much. Good morning, everyone. I'm going to start with a quick comment. How many of you have heard there's a particular city in the Old Testament where most educators have come from? Anyone know where it is? Babylon. So I've been given only 10 minutes this morning, and I'm going to try to stick with it, and we're a couple minutes behind, so I will try to stay on target. I do represent the Caregiver Resource Network, and I'm here today to talk about community resources. Why is this important? Because those families that we've been talking about this morning who are struggling with this caregiving task, something which has been dubbed the 36-hour day, which is truly 24/7. How many of you have been family caregivers? How many are currently family caregivers? Anyone in the past has been a family caregiver? Well, former First Lady Rosalind Carter says there's only 4 types of people in the world. Those who are caregivers, those who have been caregivers, those who will be caregivers, and those who will receive care. So this is an area that's going to touch all of us. The problem is that families who do this yeoman job we've been hearing about, they try to struggle on their own, and they do it all on their own. You realize that nationally, only about 10 to 20% of the family caregivers take advantage of any of the community resources that exist to support them. Well, you wonder why burnout rates are so high. What we need to do as professionals is we need to encourage the families and steer them toward these resources. Because in accepting support, it's not taking away from their caregiving role, it's enhancing their caregiving role. It's enabling them to do a better job as a family caregiver. We are blessed here in this community in West Michigan to have what I believe is the best aging services network in the entire country. Problem is, very few people know about it because it's made up of small nonprofits and small for-profits that many times operate very much like the nonprofits. And so very few people have any kind of resource to do any kind of marketing or tell the community about what they have to offer. So in 2001, we came together as a community and we formed this group called the Caregiver Resource Network, which is now a collaboration of over 120 community organizations, which all work together basically to share information and resources, to educate family caregivers and point them in the direction of resources to support them in this difficult role. Why did we do this? Because again, when we first formed this, we knew that the average family caregiver, even when they were ready to ask for help and were seeking help, would make 8 to 10 phone calls before they'd get a hold of someone who could really help them. This is a complex system, as you can imagine, and they need direction. And so the Caregiver Resource Network is a way to collaborate, share that information, and jointly educate the community. What does this mean to you? You don't have to become the community resource, champion who understands all the resources. What you need to know is the Caregiver Resource Network is there to support you, to support the families. So this is really the best resource for you, I believe, in many ways. This is our website. The Caregiver Resource Network is at caregiverresource.net, and you'll see a flyer in your packet. Okay? This is the top of the home page, and just a couple of things that I will point out. At the top on the right-hand corner, you do have a search bar. So if you want to type in any particular type of element related to care, perhaps you want to know more about dementia or Alzheimer's or about respite care, you can type it in there and it will find everywhere on the website where that is referenced. The reason I say that is we have thousands of items on this website. We receive between 20-some and 30-some thousand hits a month from all over the country in terms of our website because we are so content rich. Underneath, we also have a language, I believe Google Languages, so someone can pick it in a different language if they need it. We highlight something at the top. We're highlighting right now a family caregiver series, which if you check out the Caregiver Resource Network table in the back before you leave, please do, has a flyer for this series of 3 free events that we're doing to, 1, pamper family caregivers and show them our appreciation, and 2, educate them, which is our mission. We have on here, every single month, we develop a new Caregiver Corner column, and this is an article. This month's is featuring an article on depression in older adults. It's not normal, okay? We have a Caregiver Corner radio program with podcasts. They're a half hour in length. We now have 31 of them linked to this website. So if someone doesn't like to read, they can learn more about 31 different topic areas currently related to caregiving. Every month we have a monthly calendar of events, and that's under upcoming events. These are all of the educational and support group related activities for family caregivers in our community. And we usually have 2 months at a time. So right now we have October and November. And we do something called a focal point. The focal point is basically I do some web research each month, and I highlight some great websites and resources out on the web. So that's new information all the time. On the bottom of the page, okay, we have a speakers bureau. So if you represent a community group, a church group, a civic group, We have a speakers bureau, and we will provide speakers for any group free of charge on any topic related to caregiving, and you'd contact me, and there's more information there. We list the Kent County Senior Millage related services. There are actually 36 different categories of service related to caregiving and families and aging that are available through the millage right here at this location, and that's kept up to date. We have a new professional educational opportunities calendar. This is a calendar of events for professionals each month, such as this event. So if you want to know more about what we're offering to professionals related to caregiving, it's there. And then there's some information about us. Some other page captures. I couldn't go on the web here. There's no Wi-Fi. That's why I'm capturing these pages. If you look under calendar of events, you'll see we always have the latest, but we also have our past year for history. The professional education opportunities, again, I showed you the link on the front page in terms of how to access those. This is an example of the professional educational opportunity calendar. Again, I can only get one shot at a time to show you an example of a type of training and how you can get that information. Written materials. We have probably, I know, it's hundreds, probably 300 or so articles that we've written since 2001 on just a wide range of topics of interest specific to family caregiving. So again, the best way to find it is not to look under these categories, but to use the search bar at the top. And this is under services. Up on the top, you see services. We offer a list of services in under 19 different categories in Kent County, specifically to family caregivers, and also throughout West Michigan. So we have both choices there. And that's a great way to find the agencies, find out what they're offering, and even have web links back to those agencies if you'd like to look at that. This is a sample of what that page would look like. Of course, it scrolls for a long ways. Nice way to look at this too, so that you don't have to look up everything. I think it's like 19 pages. You can jump to a category, use the drop-down arrow, and it shows you the categories of services. So we try to make it easy for people to find information. This is a sample of the 2013 Kent County Senior Millage Services flyer, which again you can download off of the home page where I showed you. And lastly, this is a capture of the radio programs. So again, you can see that you can download them to your portable device, or you can listen to them on the computer. Wide range of topics. With that, what I want to call your attention to again is that you take time to stop by the CRN. You can see our poster board in the back, our display board. You pick up additional material. And I would ask that you help to promote what we're doing in the community, because this is about educating families. They are desperate, and they need all of our help, and we can't do it alone. And the last plea I'll give you is if any of you want to join the efforts of the Caregiver Resource Network, it is not exclusive. There's no membership fee. The fee is actually your work. We meet every other month. We have a variety of committees, and it's really a working group. We're all about educating the community. And we have financial planners, we have attorneys, we have all different categories of service providers. So if this is an interest area of yours, come join us and be a part of what we're doing. If you're interested, you can see myself or Ann Ellermitz in the back. Thank you.
Thank you very much, Mike. While our panel is reconvening up here, if y'all want to make sure you fill out your purple evaluation sheets, there is going to be a box on the table where you registered and came in where you can deposit those. We have some wonderful questions, and I'm going to try to get through all of them. So even though there are very thorough answers you could give, if you could be really succinct, we'd appreciate it. Julie, I think I'll address this first question to you. What is the difference between a payee and a conservator related to the duties for the person's finances and related to the legal status of each one of those? The difference between payees and conservators.
I think I might just defer to the judge since I don't.
You don't practice here.
I don't practice here. I mean, I think you're best suited.
payee is someone who is basically appointed by Social Security to manage that person's government benefit, and they do not need a guardianship or a conservatorship in place. In Kent County, we typically, although sometimes do, we typically don't manage that asset because the payee has to account to Social Security for the benefit on a yearly basis. If I have suspicion that that money itself is being abused because of the person's only funds are Social Security, and I got a deficit at an AFC placement, that's a flag to me that those limited government benefits aren't getting to where they're supposed to go. But there's no involvement by the court typically. Typically, when you become the guardian, you become the payee to manage that asset, but you can be a payee without being involved or being appointed formally as a guardian or conservator.
And this is a related question. As long as you have the microphone, I'll address it to you again. Can you discuss when you appoint a professional guardian or conservator instead of a family member?
Typically, I always prefer a family member for any number of reasons that you can guess. You assume that the family is a preference to the respondent ward who is receiving that. Sometimes, I shouldn't say many times, but with some frequency, particularly if it's an adult child maybe, and they may have a mental health issue that has become, or it has been, very difficult to manage and deal with. Sometimes family members like to walk away and say, we just want to be parents. Our relationship's already been strained or ruined or frayed, and we want that professional. Now, we look more and more to family members, not necessarily because they're better fiduciaries, but because we are basically out of guardians to manage cases in Kent County from the professional program. But if I have someone who has a criminal record, who's been assaulted, who has been convicted of a crime of theft or dishonesty or false statement, those are generally disqualifiers for me. I had someone in front of me yesterday who wanted to be a guardian for a friend. Of course, I had a flag because I had an unpaid bill at an AFC. But she had a record that spanned from 1990 until 2012, and she said, this is behind me. And I said, not really. I said, are you still on paper, meaning if you did criminal work, as I did 30 years ago, that means are you on probation or parole? Are you on paper? And she said, oh, no. But I said, well, from 1990 to 2012, you've engaged in the delivery of cocaine, the delivery of 5 kilos of marijuana. I'm not kidding, 5 kilos of marijuana. There was an attempted larceny in a building, and she just looked and she said, oh, I didn't really do that one. And I'm like, oh, well, so my mistake, or you see things, domestic violence. So we denied the temporary emergency hearing yesterday because I didn't find an emergency, and it also bought me time to investigate whether there was an available resource at the professional guardianship program or other organizations like Servant Center or places like that. So the unsuitability of the family member, either because they've stolen, they have a criminal record, and there are many built-in provisions in the statute that really require the court to take all of the wishes of that person who's being given a guardian. I mean, we just don't say, this happens. I mean, we are basically mandated to accept that person named by the ward unless they are, quote, unsuitable. So there is a preference for family. We give the preference and choice to the ward if we can, but many times that's just simply impossible.
And in making that determination, we have a lot of medical professionals with us this morning, and there was a question regarding, in the contested matters, what type of information do you need and what type of medical professional do you prefer to hear from? Is there a hierarchy in whom you like to hear from?
Well, I would think that one of the tools most helpful to me, on a short-term, short-circuit basis, all of my guardian ad litems typically perform mini mental status exams on the person who is subject to the petition, where they do the 30-question test or a BIMS test, a brief inventory of mental status. If it's more complicated, if there's a dispute, the court always has the authority to order a psychological or neuropsych. But neuropsychs are kind of the, well, I mean, that's a heck of a test for me to look at to guide the court in what we look at. And other medical or treatment records, frequency of, we haven't talked about involuntary mental health treatment, which occurs at Pine Rest and St. Mary's Psych Med and Forest View Hospital. Those are sometimes, they move in conjunction or parallel many times for a guardianship hearing, or many times it's kind of used as a shorthand step to get control of that client who may have severe symptomology from those Alzheimer's, whether they have become assaultive to caregivers, as one example. So neuropsychs are most helpful, I think, along with those other much more, the Folstein mini mental status exam.
This is a question I think maybe Suzanne and/or Kathy and any one of you might address. A lot of times family members struggle with initiating a guardianship or conservatorship. They're afraid that might destroy the relationship or certainly impede the relationship. Are there alternatives that they might consider?
I actually usually encourage patients to get their affairs in order, like what you were talking about earlier, for all adults. Who do you want to be involved in helping make these decisions? If the person still has capacity for decision making, to look at doing durable power of attorney documents. I know that there are risks. It's what I usually encourage people to consider. And usually what I do with the families I work with is encourage them to raise these conversations and say something like, this is really hard for me to talk about, it's uncomfortable. I just want to make sure that whatever your wishes are, that I know what they are, so that we can help make decisions if, God forbid, something would happen to you in the future and you weren't able to make the decisions for yourself. So.
I think that you should encourage the person in their estate planning documents. They can name their fiduciaries, and they should name their fiduciaries. So you can name them for your children if they're minors. You can name them for a disabled child. You can name them for a spouse under certain circumstances. So exercise that ability that you have and make the choice yourself and put it in your estate planning documents. Do your durable power for health care. I know there's a program that's being developed, I think, through Dr. Fox at Spectrum that talks about this kind of continuum of planning for medical care and what should happen and what kind of surgery should you have and with your diagnosis. And I think insurance companies are going to end up wanting, and I think they have in jurisdictions out of Michigan, insurance companies really want that to happen, and they will pay for those consults, and they've had folks who do that consultation work right in the hospital. Insurance companies are doing it because, of course, it saves them money because they map it out and people face those questions then that you talked about, those very difficult questions of, if I'm diagnosed with X, what should my course of treatment should be? And I talk about it with my wife, and do I want to go through that treatment and balance what are the odds, and should I, what about the rest of my family, and where am I financially? So, you can't stress enough early planning, but name your fiduciaries because you can do that.
Here's a quick question, I think. If a husband or wife has dementia and is in a nursing home, does the wife or husband need to be a legal guardian, or is the durable power of attorney sufficient?
That's a good question. You shouldn't need a guardian if you have durable power of attorney to do things like placement in a nursing home. Some demand it. There's been discussions on the listservs about it's like banks, they always get upset with banks denying durable power of attorneys, and sometimes banks do deny durable power of attorney and say, go get a guardianship. We want the court's blessing and a court seal on the document. Well, there's really kind of a given or a push and pull regarding those documents. Sometimes banks don't like durable power of attorney because I think many times they can be misused. Many times you're told you got to be a guardian to apply for Medicaid. That's not really true, but if you look at attorneys or estate planners, they will tell you that we've been told you've got to go get a guardianship. So I think you have to be firm. You've got to be an advocate either for yourself or have your spouse or family or someone else be that advocate for you. This is a whole new world in medical treatment and care, and you better have a voice. But you shouldn't have to have that formality. Sometimes the VA does it to us. Mm-hmm. It's like the VA's like, oh, no, you got to have a guardianship. Well, but, that's a problem somewhat beyond my control because they just come and ring my doorbell and we see whether it fits the criteria.
Julie, a question arose about professionals navigating the whole privacy issue when they're working with clients in terms of a daughter calls or a son or a concerned spouse that their loved one doesn't seem to be capable of making decisions any longer. And how can you work with them and yet not violate confidentiality?
It's very tricky because, unfortunately, as the judge mentioned before, people often wait till crisis situations to reach out and make contact, and, we'll get the call after the child has been in their parents' home and has seen bank statements with large withdrawals that they suspect that somebody else is involved, and that just becomes a very tricky situation because unless we have written authority, we really can't be speaking with these people. But oftentimes, especially at our institution, we have family relationships where different people have different accounts. So then you look at, well, do you have authority to talk to me on this account, or do you only have authority to talk to me on your account? And really, at that point, we need to encourage them to go talk to counsel and potentially be filing a petition for guardianship, and kind of just touching on that point about people not wanting to because it is unpleasant, and this is your parent or your sibling or whomever it is, and it's sad, but the alternative is much worse. And so if you're able to step up and file the petition before things get really bad where somebody's taken advantage of them, or just bad choices are made even from themselves, making bad decisions like the one you referenced about the man who called and canceled all of his policies. Making the tough decision at the right time is the right thing to do. So I would encourage people to call counsel.
The capacity worksheet for lawyers that's in your packets, somebody asked, how does that score to determine that preliminary conclusion of severe cognitive impairment in Part D?
Okay. There's not a formal scoring system. One of the things that is also another handout is the citation for this that's in your handout. You can download this document, the Assessment of Older Adults with Diminished Capacity, a Handbook for Lawyers, and it walks through basically how you need to fill out this document and actually suggests that you review that before using this document. So it will give you more detail, but it's not like the Folstein where you get a 30-point score and then everything is apparently okay, or a 10-point score and that triggers you. It's more weighing those different factors that are in there. And I think one of the things, too, I would just really encourage is to look at consulting. Consulting with colleagues, consulting with people that have expertise in this area, whether it's geriatricians or neurologists or neuropsychologists, psychologists, social workers. There's a lot of resources in our community with people that have this expertise clinically. I get calls from people sometimes, and they're like, can I just walk this case past you? I just want to get feedback on how does it look to you? What are you thinking when you hear me say this? And those are really actually pretty welcome calls, I would think, from Kathy and myself, and I know my colleagues at Pine Rest at the PCC get calls like that too, just wanting to get more information. Because it's actually, in my estimation, it's much easier to see we've got some severe problems going on here, where it's a lot trickier when it's mild problems or more than mild problems to raise issues or figure out, do I say something? Do I not say something? How am I supposed to say it? Those are really tricky conversations. And as professionals, we can feel really uncomfortable. But I think your comment earlier, Julie, about you just need to get comfortable being able to talk about these difficult things with families. So did that answer the question?
Well, I'm looking at, I think it did in the time that we have allotted. There are other questions, and we can answer those, but if y'all need to leave, I certainly understand it, because we did say we'd conclude by 11. But there are two questions here that I think might be of interest to everybody still. And one is, Judge, can you talk about how once a client is determined to be incapacitated, can they change their DPOA?
The short answer is no. The short answer is no. Because, particularly if it's a full guardianship, because they've been found to be fully legally incapacitated, and they're signing documents. It's like signing, a contract. Now, there's also been a discussion whether, and there's some case law that would show like the ability to draft or sign a will. That goes. That's somewhat more fluid, and say, well, did he meet those 4 requirements that I talked about earlier? Does he know that he's disposing that property after death, what the property is, objects of his bounty, understands the cause and effect of doing that? But you're going to come up with a basic presumption that he or she is incapacitated, so that's dangerous. Let me say one thing and answer a question you haven't asked me, and that is never go to a document preparation service. Don't go to people who aren't attorneys, who are not supposed to give you legal advice, who prepare these standard form documents that you can't really retool without counsel or without a trained professional. It will cost you 50 times more than what you saved by going to a document preparation service versus a licensed attorney, because they always come back, they're always poorly drafted, they don't meet Michigan law. Typically, we are very concerned about the unauthorized practice of law. So my free words of advice today are, don't use a document preparation service, because they are filled with pitfalls. So.
Kathy, I think our last question I'd ask you to address, how do you recommend that beneficiaries learn about their parents' wills and trusts, and how can they avoid conflicts within families?
That's a tough
That's
question.
a 2-day seminar.
You have to approach it very carefully so as not to put the other person on guard. Most older adults want to protect their financial information. So the best way to do it, I don't know if it's the best way, but one way to do it would be to just sit down and talk about if something should happen to you guys, where's your paperwork? Or something like that. Ask, where do you have everything? Because otherwise I've got to try to find it all, and there may be money out there that I don't know about that will be lost if you haven't shared any of that information. But it has to be done very tactfully. Again, it depends on what we've all said about what kind of a family relationship is there. And if the parents do not want to share that information, then maybe they'll share it with someone, a third party, like their pastor or something like that. Put all the paperwork in a place. If something happens to me, it's in my lawyer's office or someplace where it's available after they're gone, but encourage them to get all this preparation, like the judge said, get everything in order, and just prevail upon the parents to don't leave me with a mess.
I was going to say, just hope that it's not in paper stock certificates in boxes in their basement, or in like $100,000, $100,000 CDs at every institution in Chicago. Because that's some people's version of estate planning.
That sounds like experience.
It's a lot of money, just a lot.
You can file your wills at the probate court for a nominal fee, and the originals are held there under wills no proceeding in Michigan. So we have drawerfuls of wills, are tightly regulated, really I'm not sure anyone can look at it, maybe under certain circumstances, perhaps a conservator regarding planning on occasion, but it's tightly regulated, but you can file those directly with the court.
I encourage families too to do the same thing Kathy's talking about. And sometimes if I work with adult kids and they're very reluctant, I'll say, tell me what happened with your grandparents. How did things go for your mom when her dad died and when her mom died? Because they have stories, and their life experience of how those things were handled can sometimes help the adult kids say, I don't want it to go like it did with grandma. I don't want it to be something that divides our family like that happened. So how can we make it different than that?
This is a question I have to ask. It's a curious one. Can you talk about laws surrounding patients with dementia and their rights to own firearms? Before the family conversation.
I'm trying to think if there's a specific statute that forbids that. There's not. If you go through an involuntary commitment hearing in Michigan, you automatically go what we call into the LEAN system, which is the Law Enforcement Information Network, and you typically stay there until death. Judges do that because if police approach that person or approach a vehicle, that will then come up that they have had involuntary mental commitment proceedings that they've been involved with. I get requests to remove people off lien. I've done it once in 8 years because I do believe that protection of law enforcement, and that's why the statute is there, is important. But I had a gentleman, not really within the last month, it was the first time ever I have ever granted that. And I look for a 10-year period of mental health stability, no further inpatient hospitalizations, and of course he was employed. He actually had a drug reaction 10 years ago, and that developed symptoms that met the criteria for certain diagnoses under the DSM-4s in the Michigan Mental Health Code. But I took him out of that system, and I do it with some trepidation because about 10 years ago we had someone who shot an officer and then killed himself on the Beltline here about 10 years ago. But that lien notice came up. And that's a big discussion like on listservs and things. But for an MI, they're restricted, and I think the filing also triggers that they can never have a carry permit, which is different than being a possessive firearm and go hunting. With dementia, that question really hasn't come up. That is, I think, a discretionary decision made by the fiduciary, whether he or she can either participate in hunting, hunting, or whether they should possess. I would think that would be just fraught with danger, giving the diagnosis. Hell, maybe I just assume that they all take the firearms away. But
no, I was just gonna make a comment. So clinically, that issue is a very significant one. So it's a safety issue, and certainly raising that with the family. So I had a case of a woman. Her husband has Lewy body dementia and has some guns at home and is a little erratic in his behavior. And she was actually worried that she said, sometimes I just get afraid he's going to get angry and shoot someone. And so we talked about it as a safety issue. We pulled the family in, the adult kids came in, we had a discussion about the safety issues. One of the safety issues were the guns. Another safety issue had to do about the driving issue. And we framed it as, how as a family would you like to handle this to make sure that everyone's safe? Because everyone needs to feel safe, and he still had capacity for decision-making at that point. So we created a plan. Where did he want those guns to go at some point? And how could that plan be put in place? So one gun he wanted to go to, a grandson, another gun he wanted to go to a brother, another gun so he helped create a plan, and now the house is gun-free, So, but it was a slow process. It took us a few months actually working on that particular issue.
But he had control and
But he participated in that, and that was the tricky part, to have him feel like he was a participant in this and not this was something being done to him, get rid of this. So it was tough.
Thank you all for those fascinating questions. Thank you for your attentive listening this morning. If there are other topics that you would find helpful to address in the future, please note those on your purple evaluation sheets. And our special thanks to our panel, to Mike, Judge Murkowski, Julie, Kathy, and Suzanne. Thank you so much for your expertise.